5, 4, 3, 2, 1. Good morning, everyone. Thank you so much for your patience this morning. We were experiencing technical difficulty. You could hear with the sound system being live, you could hear us talking, but we could not hear you. And just appreciate your patience this morning. I'm going to, at this point, this is something I don't normally do, but to make sure everything is operating correctly still, going to use the agenda and call the representatives' names to make sure that we can hear you and that everything is still working correctly. The purpose of this morning's workshop is to address again our procedures regarding termination of service. And we invited the Department of Health and Environmental Control to participate in this second workshop. And they have not only participated, they've also provided comments, and we really appreciate their participation and their written comments and their participation today. The other issue that we are going to address this morning pertains to the Commission's water and wastewater rate application filings and the substance of those filings. So the first water company on this morning's agenda is Blue Granite Water Company. Mr. Wellborn.
Good morning, Jocelyn. Yes, I'm here and present representing Blue Granite Water Company. I also have with me Dante DeStefano, who is Director of Regulatory Affairs for the company.
And we can hear you, and that's awesome. So thank you, Mr. Wellborn. Thank you, Mr. DeStefano. For Southwest Water Company Utilities and Palmetto Utilities, Mr. Terraney.
Charlie Terraney, and I have with me Brian Barr and McHugh Morris.
And Mr. Terraney, will it be okay for us to include items 3 and 4 at the same time today? They're listed separately on the agenda, but is it okay if we just recognize you for both of those at one time, take those 2 items together today?
Of course.
Thank you. Department of Consumer Affairs, Mr. Hall, can you hear us?
Good morning. Can hear you loud and clear, Jocelyn. Also have Connor Parker with me today.
Oh, Mr. Parker's present too. Awesome. Thank you. We can hear you. Music to our ears. Office of Regulatory Staff, Attorney Huber.
Good morning, Jocelyn. This is Chris Huber here on behalf of the Office of Regulatory Staff.
Thank you. And the Department of Health and Environmental Control, Mr. Sean Clark.
Yes, ma'am. Hi, how are you?
I'm doing well, Mr. Clark, and thank you again for participating this morning and troubleshooting something for us that we weren't aware of.
More than welcome.
All right. So we're going to start with Blue Granite Water Company. Mr. Wellborn, would you please provide, I know that you've already provided a summary at a previous workshop, but you filed a letter after the earlier workshop related to rate applications and termination of service. But anything you would like to, any summary you'd like to provide this morning, you in conjunction with Mr. DeStefano, that would be awesome.
Thank you, Jocelyn. Mr. DeStefano will be available for any follow-up questions that you might have. As you mentioned, we've discussed these matters to some extent and at some level in prior workshops. And I would refer Commission staff to the letters filed by Blue Granite in this docket 2020-247A on March 17th, 2021 and March 26th, 2021. Those letters go through Blue Granite's perspectives on these issues, and I'll briefly recap those positions without going into too much detail since we've discussed them previously. But first, Blue Granite opposes, in general, filing direct testimony with rate case applications, primarily due to regulatory lag and because other parties don't tend to rely on testimony, in our experience, when developing their own testimony and positions in the case, rather they're relying on the application and supporting materials instead. We also don't believe that supporting spreadsheets and data should be filed along with the application, but instead should be provided through discovery. And relevant to that matter, we also don't believe that applications in general should be uniformly formatted that utilities and businesses in general keep their records sort of in their own way, and to have to sort of reformat them, plug those into a uniform format wouldn't be efficient. Sorry,
Yeah, there's someone, we can hear someone else's conversation. You might want to mute everything on your end, everybody else, if you're not speaking, so we don't hear conversations. Okay, thank you. Oh,
all right. As related to minimum filing requirements, we generally agree that starting from sort of what we generally are required to file in South Carolina, building from there based on identifiable gaps in information would be a helpful approach. And that we've also provided specific feedback as to the Arkansas MFRs as applicable to water and sewer utilities. For disconnections, just a brief recap there, we would propose that utilities be allowed, as we've discussed before, to leave a door hanger for a notice. We understand that that's a pretty common approach and would minimize person-to-person contact. We don't think there should be an additional mailer. We already have 2 certified notices. In general, I think we do support DHEC's proposal that there be an electronic service of disconnect notices. Having that option available would be helpful. I think that's the overall recap of our positions. And Mr. DeStefano, if there's anything that you'd like to add, you're welcome to. Otherwise, we can pass to the next utility or see if Ms. Boyd has any questions for us.
I don't have anything to add at the moment, but I'm open for questions.
okay, thank you, Mr. DeStefano. I have one question, Mr. DeStefano, on the referring to Blue Granite's filing, responding to Commission staff's initial recommendations related to the minimum filing requirements using Arkansas's MFRs. And the last page, page 4 of 4, would you remind me, I just couldn't find them immediately, or I couldn't find the responses. On page 4 of 4, per DCA, the number and location of complaints, and it says see BGWC comments. Would you tell me, please, your feedback regarding that recommendation? Do you know where I'm on the filing that was made on March 26th by Blue Granite? And the Arkansas minimum filing requirements, and the company filed responses related to, or notes and comments related to the commission staff's proposal. And
Yes,
okay.
I have those in front of me. Which page were you looking at? Oh, I'm
Page-
sorry.
Okay. So this, for the company's entire filing, it would be page 7 of 7. It's the last page. And it's under, my question appears under performance and operations metrics per Department of Consumer Affairs, number and location of complaints.
Yes, I see that.
All right. And I think Blue Granite Water Company had some feedback regarding that particular
yeah.
recommendation. Would you please?
Yeah.
Thank you.
Sorry. Yeah. So I think we had some requests for clarification at the end of our comments. And one of those was pertaining to the customer satisfaction data note. So I think that was all we were referencing back to, and that the company would request some clarification on kind of the scope of the data that would be needed or required. Is it test year? Is it multiple years? And also if a company has also an existing complaint, compliance filing or something like that, summarizing their complaint activity, would that suffice in its stead? So just some clarification on that.
Okay, more detail on this one.
Yeah,
Okay.
on the parameters and scope. Yes.
Thank you. Okay, and I'm appreciative that Mr. Wellborn filed. I mentioned earlier about electronic service, and I noticed in the company's comments that were filed after the first workshop that he mentioned the My Utility Connect billing module. Thank you for including that information in your later filings. And you've responded with more detail also regarding the effectiveness of door hangers. And I'm appreciative also, Mr. Wellborn, of you being responsive regarding my questions there. And I know that ORS, Office of Regulatory Staff, provided some feedback. I am going to ask Mr. Hall his opinion of that, but thank you. I really don't have anything else right now. Mr. DeStefano and Mr. Wellborn, thank you for your time.
Thanks for having us this morning. We appreciate it.
Thank you. We will move next to Southwest Water Company Utilities and Palmetto Utilities Incorporated, and Mr. Terrainey, Mr. Barr, and Ms. Morris.
Okay, well, my job's easy today because I am going to let Brian Barr speak on behalf of the minimum filing requirements and Ms. Morris address our recommendations about termination proceedings. So without further ado, I'm going to let Brian take over and speak about MFRs.
Thank you. Good morning, Mr. Barr. I know
Good morning.
you may proceed when you're ready.
Thank you. So my name is Brian Barr. I'm Director of Rates and Regulatory for Southwest Water Company. And on behalf of our subsidiaries here in South Carolina, we're appreciative of the opportunity to participate in this process. And we feel it's an important process to take place in that continual improvement is important and something that should always be strived for. In this particular instance, personally, we're really glad to participate in this case or in this project because we feel like the interests of all the parties are aligned. And you may not get that from the letters that have been filed, but we feel like the interests of the parties are aligned. And so it's an opportunity to collaborate and work to try to find the sweet spot, if you'll allow me to say that. The record is fairly expansive and full as far as what our position is, so I won't spend too much time recapping what our specific points are with regard to minimum filing requirements and filing testimony at the time of the application. We're aligned with Blue Granite in that we feel that testimony should not be filed at the time of application. And then at a higher level, with regard to minimum filing requirements, I'm going to make a bold statement, and I hope it's taken with the intent that it's said. And that statement is, I believe that before we seek to change the minimum filing requirements, we should analyze the minimum filing requirements that are in place and use those as the basis for any changes that need to be made, rather than initially looking outside of this jurisdiction, looking to other jurisdictions without evaluating whether those other jurisdictions' minimum filing requirements are indeed effective. In my position at Southwest Water, I'm responsible for regulatory filings in a number of different states. So I've had the opportunity to see the minimum filing requirements and the rate application requirement in several jurisdictions. And I can honestly say that in South Carolina, these make the most intuitive, logical sense. When I say these, I mean the ones that are currently in place. In Texas, for example, we have minimum filing requirements, and we also have a uniform filing package that needs to be filled out. That uniform filing package is an Excel spreadsheet that consists of 256 pages, individual schedules, plus work papers. And when it comes to rate applications, the principles that we should be striving for are accessibility, transparency, understandability, uniformity, flexibility. These words that end in Y. And ultimately, there's a balance to be found between accessibility and affordability. One thing I would ask the commission to consider is that as the requirements become more stringent, the costs of meeting those requirements go up. And ultimately, to the extent those costs are prudently and reasonably incurred, and that they're incurred to meet regulations, those those costs are recovered from customers. And as a utility company, as the parties to this case, I think we should analyze the potential changes through that lens as far as determining if they're really useful, necessary, and beneficial to the customers. As I mentioned, in Texas, there are filing packages, 256 individual schedules. Our last filing package for the rate case was 1,500 pages, and I can guarantee you that it's neither accessible, transparent, nor understandable. So I really think that in South Carolina, we already have minimum filing requirements. We have a process in place that's, in my mind, very understandable, very accessible, and allows the utilities flexibility in meeting those requirements while still providing fairly uniform filings. It's not like there are 50 different Class A water utilities in the state, and each one is doing its own thing. The filings are already fairly uniform. So once again, my two main points is I would like to reiterate is the commission, the rules already have minimum filing requirements that are that meet the sweet spot of accessibility, affordability, understandability, and usefulness. And I think that to the extent any changes are made, rather than looking to Arkansas or another jurisdiction, we should look at what efficiencies are in those minimum filing requirements and then fill in the gaps. And I'm available for questions. That's the end of my comments.
Thank you, Mr. Barr. Thank you for your comments too. Just looking at for example, the rate applications, regulation 103.512.4, do you, based on your review of these, do you see where there could be any improvement in the current requirements in South Carolina?
That is an excellent question. The answer, frankly, is no, I don't. I think that the information that's required there, including financial statements, pro forma financial statements, I think that serves as the basis of what is ultimately needed to file a case, to understand what the basis of the case is, what the cost justification is. I think that is the nuts and bolts of what needs to be included in the case. And to the extent that there's additional information required beyond that, and there generally is, but that it's more appropriate to request that through interrogatories as opposed to minimum filing requirements.
And if I may add to that, Jocelyn, it seems that some of the proposals are aimed at really creating discovery through filing. And there may be a procedural fix to that desire for discovery, which, there's no rule that says intervention has to be delayed until the return date. A petition to intervene could be filed upon applications being filed, and the commission could grant it the next week with if it's not opposed. And certainly intervention by the Department of Consumer Affairs is not going to be imposed. And there is no rule to prevent discovery from being served upon intervention being granted. So some of the things, if you look at an Arkansas application, which I did, there's only one, it's from way back, 15 years ago. I could share my screen if you want me to. I don't think it's particularly helpful to anybody in the general public that would want to understand a rate application versus what we have right now, which is somebody telling you how much your rates are going to go up and how much the revenue requirement is.
Mr. Torini, I'll ask you and Mr. Barr this question. I heard a similar concern at the other workshop, and I think you participated too, Mr. Torini, regarding additional information being requested through the discovery process. And I asked about, well, if that happens, if the commission doesn't change its regulations and representatives of other parties request the information through discovery, that those costs, either the ratepayer is going to pay on the front end, perhaps, maybe, if the regulation is changed, or if the other entities request the information from the utility, that the utility will still charge. Basically, the ratepayer will still have to eventually pay those costs related to discovery. Would that be the case for your client too?
Why don't I take a stab at that?
Go ahead.
I'll take a stab at that, and then Charlie can correct me.
Please.
The costs don't change whether it's prepared as part of the filing or in response to an interrogatory. The difference is an interrogatory can be more specific and actually request the information that's needed. If it's a minimum filing requirement, then it's not always looked at or needed. And ideally, the minimum filing requirements would be useful in every single case. And so to the extent that any minimum filing requirements are made that take the place of interrogatories, they should be general enough that they would be applicable in every case. Charlie?
Well, in my experience, and this is an intuitive question, right, Jocelyn, because we don't know, but I think what will happen is you'll simply have a voluminous minimum filing requirement coupled with a voluminous discovery request. I mean, we already have, routinely 100 AIRs upon filing, and I would wager that we will have 100 plus AIRs if you adopt these minimum filing requirements. It won't make any difference except to add cost. Now, again, I'm guessing, but unless ORS or somebody wants to commit to limit their AIRs in exchange for the MFRs, I think that's what experience tells us.
Okay, so thank you both, Mr. Barr and Mr. Torini. I guess you're both still saying, though, that even the AR costs related to, for example, BGWC responding to AIRs or any other discovery, the ratepayer would still eventually be responsible for those costs. That was a yes.
Yes, except that I suggest that those costs will be greater if you adopt Arkansas style AIRs.
Yeah,
I don't think they'll net out.
Okay. All right. Let me see what else. Thank you both. Mr. Torini, in your comments, you mentioned reviewing United's 2006 application, and you said there's comparable information in that application to the information requested by ORS in a case. Are you recommending that in addition to using our existing regulations 103, 512.4, and 712.4, that we also review United's application, also maybe as in addition to the baseline, the current regulation as a baseline. So use all those three.
No, I mean, I think I'm not sure I understand the question, but I guess what I'm saying is United's application is the only example we have of those Arkansas regulations being applied. Because Arkansas doesn't really have any regulated utilities when it comes to water and sewer. They've only got this one company, which last filed, I don't remember the year, but it was a long time ago. So I looked at it, and I guess what I'm suggesting is it's a pretty good example of why not to adopt this regulation. It's not particularly understandable. It's generally speaking, the volume of information, perhaps not the quality or exact format that is requested by ORS, and it is better suited towards discovery, which again lends itself to remember that Arkansas is not a quasi-judicial commission exclusively like South Carolina. So when somebody's filing in Arkansas, they're basically filing for the commission staff to examine the rate case. They're filing the work papers requested basically by their equivalent of ORS, which is all in-house. So they file these applications, and they are accompanied by a motion for a protective order, which restricts a good deal of the information from public viewing. What is available for public viewing, frankly, to a layperson or even a lawyer is incomprehensible. I mean, I just don't. I can put it up. Let's share a screen. Hopefully, I'm not sharing my tax returns right now, but I think I've got United Water Part 3.
Mr. Terrain, oh, there we go. Okay. Let me see. We might have to add.
400 pages total. Part 2, I mean, you get my point. I encourage you to go look at it, but I'm just saying, in terms of what people look to DMS for, what our customers look to DMS for, where they're looking and they want to see the basis of the rate case short of intervention, I don't think this is what you need.
Okay, well, thank you, Mr. Terrain. I do know that we are going to continue to review what our initial recommendations, and we of course have reviewed what the existing regulations require, and we'll definitely look at what you have mentioned in Arkansas, but I guess the other question I wanted to ask, we talked about Arkansas, but what about the other modifications related to performance metrics?
Well, and I'll let Brian chime in as well, but as we stated in our letter, with performance metrics, if the commission wants to have performance metrics, and they were discussed in the past, as I recall, in the early 2000s, I think they need to be part of the rulemaking. So that there's some general consensus on what the performance metrics are for a water and sewer company. And they are adopted and ratified by the General Assembly. I don't respectfully believe it's appropriate to introduce them through, a general catch-all that says such other information in the regulation that allows the commission to request such other information as they want. I mean, this is going to be a substantive measurement that presumably will affect our ability to earn a fair rate of return, and it needs to be adopted outside of minimum filing requirements. We also talked about senior executive compensation and basically requested some clarification on that. If we're talking about senior executive compensation of the parent companies such as Southwest Water, we would submit that that's beyond the jurisdiction of the utility. If we're talking about the compensation of local management, then that's a different story, but it certainly should be subject to a protective order, and it's the kind of information that's widely available in rate cases anyway. We also believe that requiring audited financial statements would significantly increase the cost of a rate case and really not serve a useful purpose, but pass on additional costs to consumers. I mean, the fact of the matter is we have an audit in every rate case. The ORS audits our applications more thoroughly probably than a big 6 or a big 4 accounting firm would. Sampling expenses, examining items, and applying the neighborhood chart of accounts. I don't think it would be useful to have a local accounting firm, however good our local folks are, certify an audit. I mean, and it would be quite expensive.
Mrs. Duraney and everyone else, thank you for mentioning that. My initial thoughts when we first started earlier this year, I think it was in February of this year, that I mentioned to participants the section in those 2 regulations. There's a section that says any other commission information the commission orders must be included. And just so everybody knows, staff is not planning to recommend any changes in the interim. All the changes that we recommend, including performance metrics and compensation, audited financial statements, will be in the proposed regulation. So I need everybody, I'm hoping that everybody understands that.
Well, thank you for that. I'm glad, thank you for clarifying that. I would reiterate, though, that performance metrics are probably worthy of a rulemaking all of their own. We talked once about, I remember the commission once spoke about adopting secondary water standards, different water quality standards, different measurements. I mean, we're going to need to get very specific and talk about how feasible these things are, or there's going to be a great deal of confusion and disappointment amongst the public.
We'll keep that suggestion in mind, Mr. Duraney. Thank you. We don't want, I know that these metrics, we would not want to propose metrics that in any way creep into DHEC's or appear to creep into DHEC's jurisdiction. So, yeah, we'll keep you posted. We will, of course, let everyone know in writing what our proposed performance metrics are.
Thank you.
So, all right, let me see if I have anything else. And I did, Mr. Duraney, you're right. I see your comments on March 26, 2021, where you respond to the audited financial statements and compensation performance metrics. But I'm glad I asked anyway, because I was able to clarify an original statement that I made and to clarify that any changes that we propose will be in writing and done through a rulemaking.
Thank you.
So let me see. Okay, that's all I have, Mr. Duraney and Mr. Barr and Ms. Norris. Thank you for being present. Did Mr. Duraney, did Ms. Morris, did Ms. Morris need to add anything?
Well, actually, we were going to have Ms. Morris talk about our recommendations regarding termination of service regulations.
Awesome.
If you'd like.
Awesome. Please proceed when Ms. Morris is ready.
Please, Ms. Morris.
Good morning. Good morning, Jocelyn, and thank you for the opportunity to speak. I'm really wanting to give some insight on customer impacts. I am the customer service manager here, and I've been in this position for 5 years. I've been through a couple of rate cases, and the disconnection process that we currently have is a pain point for our customers. We believe that the current regulation, it drives excessive customer expense and dissatisfaction. And some slight modifications to that regulation would improve the customer experience and I believe streamline it for the utility. For example, the customer is required to receive a certified notification that their service could be disconnected if payment on their current past due balance is not received within 30 days. They are then mailed a second certified notification on the 31st day, indicating that the service will be disconnected in 10 days if payment is not received for the original past due amount. The customer is charged $25 for each of those letters to mitigate the cost of producing the notification. These notices are mostly returned. We receive probably about 70% of them unclaimed. And the customer is never actually receiving these notifications or picking them up from the post office. They continually express that if they didn't receive it, then they shouldn't have to pay for it. And ultimately, they do complain to the Office of Regulatory Staff that they should not have to pay for this fee because they never received the notice. The result is that it's adding a burden of $50 additionally to the current bill that the customer is struggling to pay. We believe that reducing the number of notifications or the requirement for mailing them with certified delivery would reduce the cost to the customer and to the utility itself. It would also increase the opportunity that the customer receives these notices and that they're actually read. Another challenging point with the regulation and disconnections is that if a customer initiates payment, they're removed from that notification process. And then if the payment is returned for any reason, the notification process begins back at the 30-day cycle, which is creating additional notification fees for the customer, where we would rather put them back into the cycle where they are since that payment did not clear and lessens some of the burden and the fees that the customer would incur. We believe that would limit, I guess, like a spend cycle of that collection process, and that the improvement would keep costs down for the customers that are already having difficulties paying their monthly utility bill. Again, these are just some of the recommendations that we've come up with or the modifications, and I appreciate the opportunity for you to hear them and to allow me to speak.
Yes, ma'am, Ms. Morris, Mrs. Terraini, if it's okay, Ms. Morris, how, thank you for your comments. How does because Blue Granite mentioned the door hangers, which means someone physically has to obviously visit that customer's home in order to utilize the door hanger. And then they provided information regarding the app. So may I ask how the Southwest Water Company utilities document or verify? How do you propose that verification or documentation takes place if the certified mail is not used? And I know that might sound elementary, but what other means would you use to ensure that the customer has received notices regarding termination from your companies? Or your company, rather, Palmetto Utilities.
Yes, ma'am. Well, we are in favor of a mailed notice that is not certified, that would go to the customer. And currently, anything that is returned to the office, whether it is regular mail, a bill, or certified notification, we are documenting it in the system that it's returned and the reason that it returned. And then we're doing research on our end to see if it's a bad address or if there was a mix up at the post office. So I believe that doing a regular mailing of a disconnection notice would benefit the customer and allow them to have some information about when their termination of service could be initiated.
Does Palmetto
Currently, I'm sorry, go ahead.
does Palmetto currently use, and I apologize, Mr. Rainey, if I asked this at an earlier session, does Palmetto currently use door hangers?
We do use door hangers when we are in the disconnection process. So if we visit a property and we don't have access to the equipment that we need, we put a yellow door hanger on the customer's door, letting them know that we've been to the property and that they could be up for disconnection within the next 24 to 48 hours. At that point, our office is notified for the reason that they could not disconnect at that time. And then we'll try to roll a truck back out to the property within that time frame to see what needs to be done so that a disconnection can take place.
Okay, so Ms. Mars, I'm gonna need you to repeat something for me. So you said you visit the property to notify the customer if termination is pending or they're delinquent in their account. Please say what you said again.
Okay, sure, no problem. So after the 10-day notice expires, on the 11th day, we are in a disconnection session. So the properties that are scheduled for disconnection, our field technicians go out to the property to disconnect. If they cannot disconnect for whatever reason, the fence is locked and our elder valve equipment is behind the fence, or if they can't locate the elder valve, at that point, we hang a yellow door hanger on the customer's door to let them know that we were at the property, and we'll return within 24 to 48 hours to disconnect, that some action will take place. And those yellow door hangers that notify them that they are up for disconnection or we've been to the property, they do drive traffic and phone calls for customers to call into the office to take care of a balance or a bill. So that is the initial door hanger that we use. The other door hangers that we use are if they have been disconnected. Of course, there's a red door hanger on the door. If we had the property listed as vacant, we hang a green door hanger that lets them know they have 10 days to set up service.
All right, so it's just not a standard prior. Okay, it's used when it's basically disconnect is pending. Imminent yes, is the word. Okay.
Yes, ma'am.
Okay, so you currently use door hangers, and does your company also use an app for termination, Ms. Morris? To notify the customer that the customer is delinquent? Do you use any type of electronic means other than email?
Currently we do not, but we do not use an app, but we are implementing the robocalls. I believe it's in June. So robocalls will go out to customers, letting them know that they will be pending disconnection.
Thank you. Let me see if I have anything else, please, Ms. Morris.
You're welcome. And I don't have anything else, but thank you again for the opportunity.
Okay, Mr. Terani, Mr. Barr, and Ms. Morris, thank you for your presentations today. Mr. Hall, Department for Consumer Affairs.
Yes, good morning.
Good morning.
If you, well, I was going to respond to one of the comments here before I got into our summary, and that was regarding the question of the number of ORS AIRs that may, and how, whether or not they would decrease if there were an increase in the minimum filing requirements. And I don't want to speak for ORS, but I did have this in my notes from the April 5th workshop that they stated that it was their belief that the more MFRs, the less discovery and the less audit information requests that there would be. And they believe that if an increase in minimum filing requirements would decrease the number of questions they asked. And I believe Piedmont Natural Gas also had commented at that time that they supported MFRs because they thought it helped narrow discovery. Just wanted to make those 2 points before I forgot. But back to our comments submitted in this particular session of the reg reviews. We, as the other parties have noted, we did previously submit comments under the 103-800 workshops and the commission's minimum filing requirement proposals. We had four basic comments in those that still apply here. Most of them have been discussed already, but they are that a company should file direct testimony at the same time as their application. A company should submit all their supporting documents with their application. The commission should require uniform schedules for the submittal of that information, and that all pleadings and testimony should be in Word or searchable PDF format. We also noted in our prior letters that we agreed that MFRs and schedules for water and sewer companies would be different than those for electric and gas companies. Regarding termination procedures in the prior water and sewer workshop, we know we did strongly disagree with Southwest Water Company Utilities request to eliminate the 30-day initial notice and to align it with the 10-day notice in the water regulations. Instead, we believe the opposite should happen, that the commission should consider increasing the notice under the water regulation to align it with a 30-day notice under the sewer regulation. There's been some comments about certified mail and other means of notifying customers. We do generally support certified mail, as we believe it does confirm the customer received notice before disconnection. I did know Ms. Moore said that, you know, often 70% of theirs are returned unclaimed. So you know, that is unfortunate, but we do believe at least it shows, it gives an opportunity for the customer to confirm they've received it. We definitely do not support any charges for certified mail. We believe that should be a cost for business for the company. There was reference to Palmetto Utilities, you know, $25 to send certified mail. Even I look back at their last rate case filing, you know, they had acknowledged that the cost to send certified mail, the cost itself is $6.59. So there are, you know, it's approximately $19 worth of administrative cost in there, including $12 for a computer information technology allocation fee. Again, we believe those types of fees are operation and maintenance costs. Their employees that are sending that out, that's part of their salaries that they're already getting in their rate cases. Palmetto Utilities claimed $413,000 worth of revenue from notification fees in their last rate case. That's almost as much as their TEP fees that were claimed. I believe Blue Granite's charge is $15, which is a little bit more reasonable, but again, we believe that should be a cost of business for the company. Regarding the use of door hangers before disconnection, you know, we do want to make sure again that customers receive notices, but we do have some privacy concerns about door hangers if it's an obvious indication that a debt is owed. I understand this wouldn't exactly apply to the utilities trying to collect their debts, but the Federal Debt Collection Practices Act prohibits most communications by debt collectors with third parties. We think a door hanger represents a similar scenario if it would allow neighbors to know if it was a collection attempt. You know, maybe if the message was more discreet and not obviously collection attempt, that might be okay. We've seen some examples where, you know, the message on that door hanger itself is on the back side, so it's, you know, not clear that's a collection attempt. I think some other local utilities here may be putting notices in a bag. But again, we understand that it is an effective way to reach consumers and their customers, but we do question has privacy concerns. DHEC, I believe, commented that in their red line versions to add verified email receipt or hand delivery as potential notification methods. You know, we've commented before that we're okay with alternative means of communication, as long as it's an opt-in option for the customer, not an opt-out. So we believe any regulation should require that, it's in writing. The customer has to choose to receive notifications that way. They also need to understand each type of communication that they'll receive. For instance, whether they're late on a bill, a disconnection, specifically what they will receive, either an electronic communication, a regular mail notification, how they'll be. And again, they need to expressly state that that's what they want to receive. We also believe they should be given the opportunity to receive both U.S. mail and electronic mail for certain notifications, such as disconnections. I think that basically summarizes what we've submitted so far in general response to comments that have been made by other parties. Again, appreciate the commission's time and effort and the comments by other parties, and look forward to continuing to address these important matters. Be happy to answer any questions.
Yes, sir, Mr. Hall. Thank you so much for your comments. I've written in 2 places to ask you about certified mail, which you proactively answered, and then you also provided your thoughts about door hangers. Thank you for addressing an issue that I hadn't thought of, the privacy concerns. I did not ask Blue Granite Water Company or Palmetto Utilities about how they ensure that the door hanger, the language on the door hanger, the information on the door hanger does not violate the customer's privacy. So thank you for bringing up those valid concerns there. We staff, we need to think about that as we draft the regulation. It needs to be specific enough to include some recommendations as to the substance, the language on the door hanger. So thank you again. Thank you for the recommendation about the consent, receiving the customer's consent as to how the communication is delivered related to pending termination. What about the robocalls, Mr. Hall? Do you have any thoughts related to Ms. Morris's statement that the company will utilize robocalls beginning in June to relay certain information to customers? Do you have any thoughts on that?
I guess we certainly wouldn't have the same privacy concerns with robocalls. Again, we do just want to make sure customers are getting notified, particularly of disconnections. I think as long as they, again, could opt into that option, I guess there would be a concern about having updated contact information. But I think if it was part of a variety of means, if it was the only potential communication, that might be a concern. But generally, I don't think we would disagree with it if it was part of a several types of communication. But I'd be happy to ask some of our other folks here. We rely on not just our role in these utility rate cases, but also our general authority as a state consumer protection agency here. And so I'm not involved with all the different privacy concerns, some of the other things that our other divisions do. But I would be happy to ask them about robocalls and see if they have any additional comments as well.
Okay. All right. And I'd already made notes about increasing the department's recommendation to increase the notice requirement in under 735.1 and 535.1.
Yeah, and just to follow up with that, we've heard comments that this leads to additional charges for consumers, and that a shorter disconnection period limits the number of charges. But you've got to keep in mind too that these folks are having to pay reconnection fees as well. So to say we're limiting charges, that if you disconnect them earlier, they're going to just get charged a reconnection fee, which depending on, for the water companies and sewer, depending on the type of valve or whether there's a valve present, I guess, not sure the percentage of customers that have the elder valves, but it ranges from $25 up to $500 for a reconnection fee. So that's just something to be maybe interested to know how many customers are paying a $500 fee because they don't have an elder valve versus those that don't. But that's an additional fee they're going to have to pay also.
Mr. Hall, that's all I have. Thank you so much for your presentation.
You're welcome. Thank you.
Attorney Huber?
Good morning, Jocelyn. This
Good
is
morning.
Chris Huber for ORS. I'm going to keep my summary brief, focused primarily on the termination of water and sewer service regulations, but with regard to MFRs, minimum filing requirements, and rate case applications, ORS does continue to support the consumer advocates' recommendations related to rate case applications and minimum filing requirements, including enhancing those and things such as filing direct testimony with the application. With respect to termination of service, our recommendations really have not changed from those expressed previously. We do continue to recommend adding an additional notice to 103-735.1 and 103-535.1. That additional notice would be 2 or 3 business days prior to disconnection. And there will be various options as to how the utility provides that notice to the customer. I believe in the draft language we provided and the March 9th, 2021 comments letter, some of the options we had included were by telephone or in person or by mail. With respect to door hangers, ORS does view door hangers as a reasonable in-person attempt to contact customers that would be consistent with that language we proposed. We also would not, we do not oppose adding specific language allowing for door hangers as a method that can be used. And I believe we also recommended adding a third-party notification system for disconnect notices where a customer similar to electric and gas could designate a third person to receive a disconnect notice on behalf of them. That recommendation, I believe, was also in our March 9th, 2021 letter. And as far as we do oppose the recommendation by Southwest Water to eliminate the 30-day written notice period before sewage service may discontinue. We do oppose that recommendation. We believe that 30-day notice should stay in place. Sewage is different than water in the fact that the potential environmental effects related to sewage service, and also I don't believe any sewage companies currently charge a volumetric fee. It's a flat fee per month, so you don't necessarily have the accruing or rearage that you would have with water. But really that is all the comments I have at this point. Again, with MFRs, we really don't have any further comments beyond those that we expressed previously in our written and oral comments.
Okay, well, thank you. I wanted you to were proactive and that you answered my question related to the door hangers, and I was just curious as to how that might impact your March the 9th filing. Would ORS want to amend its language in any way that appears on page 3 or 4, which I think you just stated that you would want to maintain the language that you recommended. You wouldn't want to amend it in any way based on Blue Granite Water Company's recommendation to add door hangers as an additional means to communicate.
I think the current language is sufficient because it provides for reasonable effort in person, which we believe door hangers are. But if the commission wanted to add specifically door hangers as an alternative, we would not oppose that either. If the commission wanted to make it clear and specifically list door hangers, and we understand there may be some privacy issues related to that to be addressed, but we believe door hangers would be a reasonable effort to provide in-person notice.
Okay, I see I'm looking at your language. So none of those recommendations change what you proposed on March 9th. That was one of my questions. Let me see if I had anything else. Mr. Attorney Huber. I don't think so, because you've stated your agency's opinion related to the MFRs. So, Mr. Attorney Huber, thank you. I'm going to
Thank
move
you, Dr.
on. All right, have a good day. I'm going to move on now to the Department of Environmental and Health Control. And Mr. Clark, how are you?
I'm fine, ma'am. How about you?
I'm doing well.
Thank you for letting me speak.
Yes, sir.
Hopefully everyone has seen the proposed edits. It wasn't anything that that we consider to be critical, just ways to make it a little bit easier for the utilities. As we've heard before, certified mail, and as we've experienced ourselves, certified mail is not a guaranteed way to get the message to the customer. And so we've used hand delivery in the past, as well as a verified email receipt that's worked well, from what I understand. So just a little bit of flexibility to the utilities is what we were looking for to help notify the customers. Other than that, we did have a concern that we've seen at certain municipalities, where if they're being served by two different utilities, one for drinking water, one for wastewater, if the wastewater is cut off and they're still paying their water bill, we've had cases where they continued paying the water bill with no problem and simply either opened up the clean out in the yard, or in one case went under the house and simply cut the connection point and just let it run under the house. And so that's caused some big problems for us as far as our municipal separate storm sewer permit in one of our local municipalities, at least. So we would like to see it, if they're going to disconnect the sewer, to go ahead and probably disconnect the water as well, just from the environmental standpoint of it being a Pollution Control Act violation. But that's just a suggestion, certainly not a recommendation at this point. We'd like to hear some conversation about it from the regulated community. But as far as our comments that we sent to you, just wanted to give some flexibility to the utilities out there. And that's pretty much all I have.
Mr. Clark.
Yes, ma'am.
Are you a graduate of the CPM program?
I am.
That's what, 2008.
That's the one. Yes, ma'am.
I knew I recognized your face. Good to see you.
You too.
Yeah.
It has been a while.
It has been a while. So let me tell you why you see, I'm grinning ear to ear. I had so much fun in that program. We invited you too because the staff that's present now just didn't know about DHEC's level of involvement when a customer is delinquent and the customer's sewer service needs to be terminated. And if you don't mind me just asking you a few questions, just to enlighten us here at the commissioner's staff, no commissioners are present. So when you receive these notices from the utility related to a pending and impending rather termination of service, okay, is there any information you can tell me about what DHEC does procedurally that's public information? Do you just receive that? Do you go and check on that property? Does anything like that happen on a customer level? Does DHEC take action on a customer level, or are you just made aware of the impending termination?
We were made aware of the impending termination in most cases. We did update the language in here due to some internal changes we've had. It's now the Bureau of Environmental Health Services.
Yes.
Before it was essentially, okay, just notify the department. And so with 1,000 folks in our environmental affairs side of things, sending just a random message to the department doesn't always get to the local staff that would have the ability to go out and look at the individual residences that are disconnected. So we'd like for that to be changed to our local office, so at least those inspectors can go out and take a look at it.
Okay.
I did hear from a few folks that they have not been receiving those simply because it probably didn't come to the right area.
Yeah.
And so we would like for that to be clarified a bit.
That's awesome. I'm glad we invited you today. For numerous reasons. I hadn't seen you in over a decade, but still, that information is extremely helpful. And just to know that it's helpful for DHEC so that it can monitor to make sure that the environment remains safe when a physical disconnection does take place.
You know, we have had a few cases where we've been successful in getting the potable water utility to disconnect service due to the Clean Water, or the Pollution Control Act violations. But in most cases, it didn't really work out. Their stance was, well, they're still paying the water bill, so therefore we don't need to disconnect that.
Okay.
But it's been handled with 12 different regional offices out there through 8 different regions. Each one was handling it a bit differently, so we're going to try to have some internal consistency. It'll help the utilities as well. They like it when we all read from one page and not handle things too differently across the state. Okay. And so we would like to be notified so we can at least go out and take a look. And we did note in here for an imminent environmental concern, if there is no one living in the house and they disconnect service, that's not a concern of ours. If someone is living there and they're continuing to use water and essentially discharge sewage to the environment, that is when we have an environmental and health problem, and that's when we want to get involved.
So let me ask you this, Mr. Clark, for where you will cause an immediate environmental impact, would you like for us to consider language? We'll think about that because, I don't know if you want to leave that judgment. If there is a definition that describes that somewhere in your regulations that we could maybe use here, you know what I mean? Unless
I do, and I can go back and look at the Pollution Control Act and provide some suggested language straight from there, and give the citation as well.
All right. So the pollution, that's the Federal Pollution Control Act?
No, ma'am, that's the State Pollution Control Act. From the federal side, it would be the Clean Water Act.
Ms. Boyd, I'd like to add one matter for consideration relevant to this issue, if I may.
Okay, may I come back? I'll come back to you, Mr. Wellborn, I promise.
Yes, ma'am.
Okay, we'll come back. Okay, so I had one other, so that's great to know there. And then I wanted to know from you, Mr. Clark, is the appropriate county health department, do you think that language is sufficient? Do you want us to make that I'm reading the first part of it where it states, the first part of the regulation, before any sewage service may be discontinued, utility must give 30 days written notice to the customer with copies forwarded to the appropriate county health department. Are you okay with that, leaving that language?
Change that. I'm sorry, I missed that one section. Okay. To the local Bureau of Environmental Health Services.
Okay, so use the same one. Okay.
Correct. And that way it's the actual folks that deal with the wastewater systems that would be going out to look at it.
Okay, that's all I have, Mr. Clark. Is there anything else you want to add or need to add?
No, ma'am, I think you've covered it, and I'll be happy to listen to what Mr. Wellborn has to say.
Okay, and respond. All right, I'll come back to you after Mr. Wellborn. Mr. Wellborn?
Yes, ma'am. Sorry to interject. One perspective that I think could be helpful or potentially complicating here would be that for a utility that provides water and sewer service, my understanding, at least Blue Granite would turn the water off, which effectively removes the sewer issue. There are other examples, though, where the regulated utility provides sewer service, but the water service is provided by a municipality or some other non-regulated entity, in which case we wouldn't have the flexibility, to turn the water off. That may be, I don't know if there's a way to sort of clarify or fix that in the regulation or what the way around that would be. But that's kind of the concern, I think, from our side is we, in some cases would only be able to turn the sewer off and the water side as an unregulated entity. So I don't know if you have thoughts on that or if there's a way to work through that.
Okay, I made
Yes,
it.
sir.
Mr. Clark?
Yes, sir. That is something we've considered, and that is something that it's nice and easy when a single utility provides both services. When it is split up, it usually is the wastewater is handled by the private utility. And as you noted, the drinking water is handled by the municipality. So we would be appealing to them separately, not through the Public Service Commission. And that's where we have had some success in the past by referencing the Pollution Control Act. So I understand it is two separate entities in some cases, and we do not, we certainly don't expect municipality to apply, abide by regulations that don't cover them, so we'd have to appeal to them directly. Thanks. Good point, though, and that is something we have dealt with in the past.
Ms. Boyd,
Yes, sir, Mr. Turini.
I just wanted to add that it's the Southwest companies, I think, would support the ability to cut off water and sewer together for exactly the reasons Mr. Clark mentioned. We don't have many companies in South Carolina right now where that's a possibility because we have predominantly sewer-only operations. But conceptually, we think that's a good idea. Also, we agree with DHEC's recommendations regarding delivery of notice. As we've said, certified mail is really not working for us, but if we can hand deliver or email notices and keep a contemporaneous record of it, we'd be glad to do that.
Thank you, Mr. Turini. Mr. Clark, I don't think we have anything else for you. It's good to see you.
You too, and thank you.
All right.
13 years, it has been a while. So
Yes, it has. It sure has.
take care.
You too. Okay, everyone, we want to, on behalf of the Public Service Commission, we want to thank you again for attending our workshop today. Just so you know, we are going to continue to work. We have a workshop at two more workshops this month, one related to our telephone utility regulations, the next at the end of the month, which most of you might have some interest, is related to PSC notices. And we're going to brainstorm, I think on the 28th of May regarding how we can improve our notices. So I'm looking forward to that workshop too. And then our last workshop will take place in June. It's related to our transportation regulations. And thereafter, what we anticipate doing is staff is going to then generate our proposals in a packet for all of the chapters, 103, 100 through 103, 800. And so you'll receive that packet with all of our recommendations. We won't start the official process of the notice of drafting until next year. But, and then if necessary, we can, maybe by the beginning of next year, we can, instead of seeing most of you virtually, we'll be able to see some of you in person with that packet that staff has prepared. So that's our plan. And I hope that you all have a great afternoon. Be safe in this inclement weather. It's not too bad, it's just raining. And we'll see you next time.
Thank you.
Thank you.
Thank you.